Bismillahirrahmanirrahim. Dear students, we are studying the Introduction to Global Legal System, which is the subject of LLB Part 2 5 years program from University of the Punjab. Today we are going to discuss about Roman legal system. First of all, we will see that what is the Roman law. Roman law is the legal system of ancient Rome. It includes the legal development spanning over thousands of the years of jurisprudence, and this development specifically was started from the 12 tables in 449 BC to the Corpus Juris Civilis till 529 AD. Roman law forms the basic framework of civil law, in fact, and in other words we can say that the civil law is basically based on the Roman legal system. The most widely system which is used today is the civil law, and it is based on the Roman law. And we can see that the terms are sometimes used synonymously. The historical importance of Roman law is reflected by the continued use of Latin legal terminology as well. You can see that the Latin terminologies are very widely used in our legal system. Secondly, we will see that what is the historical development of Roman legal system. As I've already discussed that the development of Roman legal system was started from the concept of 12 tables, and in other words we can calculate that 2500 years before the development of Roman legal system was started. Before the 12 tables, private law comprised the Roman civil law that applied only to Roman citizens and was bonded to religion, and it was undeveloped, and it was with attributes of strict formalism, symbolism, and conservatism. The jurist Sextus Pomponius said that at the beginning of our city the people began their first activities without any fixed law and without any fixed rights. All things were ruled despotically by kings. So we can see that before the start of 12 tables, the Roman laws were unwritten, unsettled, and undeveloped. So now we will discuss slightly about the 12 tables. 12 tables are basically the first legal text dating from the mid-5th century BC. The plebeian tribune C. Trentilius Arsa proposed that the law should be written in order to prevent magistrates from applying the law arbitrarily. So basically, the concept of 12 tables was started when a plebeian person proposed that the laws should be in the written form. In fact, in Rome there were two sectarian groups, plebeians and patricians. Plebeians were basically the lower class, but the patricians were the upper class. Patricians were well educated and law knowing persons, while the plebeians were mostly the laborer persons of the lower class in the Rome. So the plebeians suggested that in order to prevent the magistrates from applying laws arbitrarily, the laws should be in the written form. And then after 8 years of political struggle, the plebeians social class convinced the patricians to send a delegation to Athens to copy the laws of Solon. They also dispatched delegations to other Greek cities for like reason. So when they decided to write the laws, they decided to send some of the delegations to the cities of the Greek in order to collect the study and legal material from those areas to help out the Romans to write down the laws. In 451 BC, according to the traditional story, 10 Roman citizens were chosen to record the laws, which were known as the decemviri. While they were performing this task, they were given supreme political power, and at that time the powers of magistrates were restricted. And after that struggle, that committee of 10 people produced the laws on 10 tablets basically, and later on the second decemvirate also added two further tablets, and in this way the 12 tables were produced. The 12 tables basically are the laws in the written form on the metallic tablets. These are basically the 12 tablets. And after writing down the laws on these tablets, these laws were shown publicly on the public places in order to see the people. So this is the basic concept of 12 tables. The next one is the pre-classical period, as we are discussing the historical development of Roman law. After the 12 tables, there is the pre-classical period, and this period is between 201 to 27 BC. We can see the development of more flexible laws to match the needs of the time. In addition to the old and formal jus civile, a new judicial class is created, the jus honorarium, which can be defined as the law introduced by the magistrates who had the right to promulgate edicts in order to support, in order to supplement, and in order to correct the existing laws. With this new law, the old formalism is being abandoned and new, more flexible principles of jus gentium are used. So we have seen that in pre-classical period, the magistrates were given power, they were given right to promulgate the laws, and they were given power to support and correct the existing laws. After the pre-classical period, there is the classical Roman law. The first 250 years of current era are the period during which Roman law and Roman legal science reached its greatest degree of sophistication. The law of this period is often referred to as the classical period of Roman law. The literary and practical achievements of the jurists of this period gave Roman law its unique shape. The new concepts and legal institutions developed by the pre-classical and classical jurists are too numerous to mention, but there are few of the examples which can describe that whatever the work was done during the period of pre-classical period and classical Roman period. We are going to discuss some of the examples of the laws in these two periods. First of all, the Roman jurists clearly separated the legal rights to use a thing, ownership, from the factual ability to use and manipulate the thing, possession. They also established the distinction between contract and tort as sources of legal obligations. So Roman jurists did the work on the ownership and possession. They separated the concept of ownership and possession. As we can see that ownership is something in which some of the thing is in the absolute control of a person. And absolute control means he can use it, he can dispose of it, he can sell it, he can destroy it, whatsoever he wants to do. But the concept of possession is a bit narrow as compared to ownership. In possession, something is in just the control of a person and the use of the person. And maybe that person would have no power to dispose of that thing or to sell it. Similarly, the Roman jurists also made a distinction between contract and tort as a source of legal obligations. So, the contract is something in which two or more persons are agreed in order to do or not to do something. But the tort is something which is the basic obligation of a person under the umbrella of law, not to harm the person and property of the other. So the Roman jurists were basically the persons who have made the distinction between these terms. Similarly, the second one is the standard type of contract. For example, sale, contract for work, contract for hire, contract for services, regulated in most continental codes. And the characteristics of each of these contracts were developed by Roman jurisprudence. So the Romans were the jurists who given the concepts for the sale, contract of work, and contract of hire, contract of services, etc., etc. And similarly, the third basic work of the during the pre-classical and classical period of the Roman development is the classical jurist Gaius around 160 invented a system of private law based on the division of all material into persona means persons, res means things, and actions means legal actions. This system was used for many centuries. It can be recognized in legal treatises like William Blackstone's commentaries on the laws of England and enactments like the French Code Civil of German. So the classical jurist, which we have discussed, that he invented the system of the private laws, in which it was given the concept that there are some of the rights which belongs to the person itself. So due to this concept, we can understand that there are two types of basic rights. One are the public and one are the private right. Private right is the right which belongs to the person itself. But the public rights are the rights which belongs to the whole of the society. And this is because of the Roman juris. So by this way, we have slightly got the idea of Roman legal system. And in today's lecture, we have discussed that what is the Roman law and what is the historical development of the Roman law. In our next period, we will discuss about the concepts of laws in Roman legal system. I hope the students would have the better idea of after listening this lecture. Hope for all the best. Allah Hafiz.